So welcome friends for this IPNet's 53rd webinar. The entire IBC is for this resolution plans only. So all my dear friends are welcome. Now I request to Madam Garima ji.
Good evening, everyone. So on behalf of IPNet Central Region, I'm very delighted to welcome you all today to this webinar in a series of webinars which is organized periodically under the umbrella of IPNet, which is a national network for insolvency professionals. And it's a pleasure to have such an esteemed gathering of professionals with us today. And we welcome you all to the 48th webinar, which is on resolution plan under IBC, implementation, effect and fallout of delays. And we take pleasure to have with us our distinguished lead speakers, IP Mr. Shantanu D. Ray and IP Mrs. Babita Jain. Your presence and experience in the field adds immense value to this session. And a special thanks to Sri Ashish Makhija, President of IPNet, for his visionary leadership in shaping this platform. The membership link is available in the chat, and we look forward to more and more people joining in with us, the IPNet network. So IPNet has become a vibrant community for insolvency professionals across India, fostering continuous learning, collaboration, and professional growth. We are committed to supporting IPs through expert-led learning initiatives like webinars, study groups, practical guidance on IBC-related challenges, and a dedicated member portal offering comprehensive resources. And for those who are already part of the IPNet, we thank you all for your support. And for others, I encourage you to join this dynamic network, and membership details are available in the chat. Thank you for being here. Let's make this session insightful and rewarding. And my apologies for wrongly naming the first speaker. We have Mr. Sankaran R, who will be introduced to the members by Ms. Sucheta Gupta. So I welcome Ms. Sucheta Gupta to please introduce our first speaker to all the participants. Thank you.
Thank you. Thank you so much, ma'am. And welcome to all the participants. Shankaran R is an advocate based in Chennai with the practice in civil litigation, commercial disputes, recovery, and testamentary matters before the Madras High Court and subordinate courts. He is a registered insolvency professional with IBBI and a member of ICSI, ICAI, IPA, and regulatory serving as a resolution professional, interim resolution professional, and authorized representative before the Honorable NCLT Chennai bench. He also hold a valid authorization for assignment till 31st December 2025 and is registered as an independent director with the IICA. He is a member of the Law Association Madras High Court campus. So over to you, sir.
Thank you, madam. Good evening, everyone. It's a privilege to address this gathering of insolvency professionals, stakeholders, and legal experts. Today's discussion is on the resolution plan under IBC, its implementation, its effect, and the fallout of delays, with a special focus on real estate. As you all know, that the IBC has evolved so much since its inception in 2016. And the latest one is yesterday's judgment from the Honorable Supreme Court, which has vast implications for the future resolutions and which will guide the COC as well as all the stakeholders. This webinar has a different perspective for different professionals assembled here. For the IPs, the topic represents compliance and professional credibility. For the stakeholders, especially the home buyers, it represents trust and delivery. For the lawyers, it represents a fertile ground of litigation and jurisprudence. I also bring my experience as an authorized representative AR for over 1,000 home buyers, which allows me to share not just law, but lived reality. With regard to the framework, approval and implementation, the resolution plan warrants the payment of the SIP costs, fairness to the operational creditors, the feasibility of the resolution plan, and the legality of the resolution plan that mandated under section 30 subsection 2 of the IBC. The next one is the resolution plan submitted by the resolution applicant shall be approved by the COC with 66% vote. The next one is after the approval of the resolution plan by the COC, the resolution professional has to submit the resolution plan for the approval of the NCLT with the Form H compliance certificate. This is read in the regulation 39 subsection 4, sub-regulation 4, sorry. And then the NCLT approval. That after the approval of the NCLT, it binds all the stakeholders, including the bankers, home buyers, etc. It is clearly stated in the SR Steel judgment. The commercial wisdom is very important. In many cases, even the NCLT cannot go beyond the commercial wisdom of the COC. So it is very clearly reaffirmed in the SR Steel case 2019 Supreme Court. Then in the JSW Steel case, that the judgment also yesterday came, that all past liabilities stand extinguished. The successful resolution applicant cannot be dragged into old investigations and attachment proceedings. This gave much needed resolution applicants, certainty to the resolution applicants. For the insolvency professionals, the message is very clear. Ensure compliance before filing the resolution plan. Then for the stakeholders, the approval means binding protection. So once the resolution plan is approved, it binds all the stakeholders. So their interests are safeguarded. The next one is for the legal practice lawyers, the scope of review is limited to section 30, subsection 2. Then after the approval of the resolution plan, then it has to be implemented. The implementation is taken care and guided by the monitoring committee. Is a guardian of implementation of the resolution plan. The monitoring committee is formed post approval as per plan. The member constituents of the monitoring committee is mentioned in the resolution plan itself, which includes the resolution professional as a monitoring agent, then representative from the successful resolution applicant SRE, then COC members, including the secured creditors. Sometimes home buyers representatives also will be considered, since they have the more interest in ensuring the implementation of the resolution plan. Then the monitoring committee, the duty of the monitoring committee during the implementation of the resolution plan, it tracks fund infusion, how the fund is brought by the successful resolution applicant. Successful resolution applicant promises the working capital, we will bring so much, no, by within the timeline, but it is for the monitoring committee whether it is acted upon, so that it safeguards the entire stakeholders for the due implementation of the resolution plan. Then construction progress, the duty of the monitoring committee is also about the taking care of, I'm talking about the real estate insolvency in particular. Whatever that left behind unfinished by the promoter, erstwhile promoter, that has to be brought up, that has to be built up once again. And they have promised in the resolution plan that they will adhere to all the approvals of the RERA, which is subsequently to be obtained since the old approvals were expired, and the renewal is to be obtained by the SRA within the time bound. Okay, so they will obtain the approvals, building approvals and municipality approvals, etc. That it is for the monitoring committee to monitor the regulatory approvals as well, because without approval, it is a starting point. Okay, so everybody should be aware that the approvals are very important to take the project further for complete implementation to the satisfaction or as per the resolution plan. In Amrapali case, it's a very famous case. In 2000 Supreme Court judgment made in 2019, the Supreme Court itself set up a monitoring committee. For the IPs, it's a transition role. For the stakeholders, it's a watchdog for the delivery. The monitoring committee is a watchdog for delivery for the stakeholders, and for the IPs, it's a transition role, because they continue till the implementation. Recent judgment, yesterday's judgment also says the COC continues till the implementation of the resolution plan, which is very important point to be noted by the resolution professionals. For the lawyers, the source of future disputes, etc. During the implementation, there may be again a lot of disputes may come with regard to the timeline, payment to the secured creditors, for these home delivery of the promised homes to the home buyers. There may be a lot of disputes. For the lawyers, the monitoring committee, it's a source of future disputes or execution and contempt. If the successful resolution applicant does not follow the timeline, or he has breached some of the terms of the resolution plan, then there will be a contempt, which will be a very hunting ground for the lawyers. With regard to the effectiveness of the resolution plan, what is the effect of resolution plans? For the creditors, it is higher recovery. They have claimed so much amount, but there may be some haircuts also. But as per the resolution plan, they should their aim is their purpose is to get higher recovery than liquidation. For the home buyers, their flats should be delivered, for which they have entered into original agreements with the promoter, and normally the agreement holders, the allottees, should not be charged more than what is stated in the agreement. They should not be charged what is in the current price of the flat or unit. They should be charged only as per the original agreement. It is also agreed by the resolution applicants normally. So we have to ensure all these things. And for the home buyers, their flat delivery is of more concern. They have waited so long. In many cases, they waited, no, already the promoter have, they left the property, left the, half finished flats. So 7 years or 6 years. Later on, the SIP came into place. After that, after the admission of the corporate insolvency resolution process, again, they have to wait till the admission and then obtaining the resolution plan. It's a very vast, that's they have to wait so long. For that, they are waiting for the flat delivered. So, and also refunds, structured refunds. With regard to the refund, we may say that normally not all the resolution applicants give much refunds. They discourage refunds. In my case, in one of the cases also, the promoter who is the successful resolution applicant encourages unit holders, that is allottees, to go for the delivery of flat rather than getting refunds. Refunds are very minimal they are offering. In one case, they are offering from 10% to 20% like that, that too after 30 months, 48 months like that. So there will be nothing is not welcoming for the home buyers. So instead, they may prefer delivery of the homes. Then the resolution plans with regard to the projects revived, then confidence restored because of the resolution plan. So these things very important. That's why we insist on the ensure we want to ensure the resolution plans are approved by the COC as well as the NCLT for the economy angle also. No, in SR Steel case, there are 92,000 crore recovery made, which is very, very big and a very successful for the resolution plan and its implementation. In Bhushan's Power and Steel, JSW Steel plan also, 19,350 crore rupees resolution achieved despite pending ED achievements, ED attachments due to Supreme Court rule that IBC overrides PMLA attachments. Then about the delays. What about the delays? Naturally, there happens a lot of delays in the implementation of the resolution plan. The reasons are endless litigation, mainly. There are cases being filed by the promoters, erstwhile promoters, RWAs, in case of home buyers, the resident welfare associations and tax authorities. So it delays the implementation, and then conflicting home buyer demands. Home buyers originally they have selected refund, then they want to get possession of the flat. So it also affects the implementation in as per the timeline. Then regulatory bottlenecks. What is that? RERA and municipality approvals. So normally is a government department, and RERA should we want the RERA approval at the earliest point of time, but it takes also, it needs some reasonable time. We cannot sit on them and get the approval overnight. So because there will be some delays on that aspect also. So funding gaps. Next is very important. The successful resolution applicant should fund the project again as promised by him. So there is no fund. So the process cannot go on. The implementation stalls at that point of time. So waiting for the funds. So these are all the causes, and also court adjournments. As we all know, the application is filed, the court going on granting adjournments. It's it's an unavoidable thing due to the overburden of the cases. The NCLT also not in a position to decide them at our own our priority and all. So these are all the causes. In Ghanshyam Mishra case, Supreme Court, government dues pre-plan approval are extinguished. So it's a very good judgment on that point. The effects is stakeholder frustration is there. Then value erosion, repeat litigations. As in with regard to the real estate insolvency, the authorized representative is appointed. In one case, from my AR role, I am telling, buyer sent hundreds of emails during adjournments. RWS even filed cases against the ARs and RPs. And as per the AR represents the home buyers, class of home buyers. His duties is to communicate notices, vote as per the as per majority, and stay neutral. So when the authorized representative discharge his duties as to represent the home buyers, there are many such occasions. The home buyers, when their anger again is since they are the aggrieved persons directly, unlike the secured creditors who expect fund money from the resolution, they want the home buyers want only the houses or the flats to be handed over to them in time after so long period of waiting. And as far as the AR, my experience, I'm telling, there are dozens of emails coming daily on daily basis for refund as well as possession demands. RWS filed petitions against the AR as well. No, AR is only representing home buyers, but apart from RP, they have filed cases against, there is a case in one of the cases. No, that originally there is some issue in the classification of the claims done by the but later it was found it was wrong and it was rectified by the orders of the Honorable NCLT. During subsequent to that, the RWA who are aggrieved have submitted the claims collectively, which is not which is unknown to law, and they have submitted the claim as RWA in their capacity. But they are aggrieved by the order of the NCLT, but somehow they have found some reasons to know that file petitions in the court. And also there are balanced expectations with transparency. In fact, there are so many, that occasions and emails, which the RP has appreciated my efforts also, even recorded in the COC minutes, stating that in his own words. So we have so brickbatted all these emails from the RWAs. Despite all their they're venting their anger and irrespective of the court orders and the provision of laws, their requirement is something so which is not known to law. So in that angle also, my experience as AR, it helped me to understand the home buyers' needs and how to pass the resolution for the home buyers and to support them in their during the implementation. The message is very clear. The AR's role, I am telling, is a very law plus empathy plus diplomacy is very much required. So I encourage the insolvency professionals to take up this awaiting position as AR, which is very much rewarding, I should say. Then coming to the implementation, the successful resolution applicant, after the approval by the COC, has to submit the performance security deposit. Regulation 36B, sub-regulation 4A, the successful resolution applicant must provide performance security within 30 days of COC approval, or it is mentioned in the RFRP. No, RFRP, if it is mentioned in the RFRP, then as per the RFRP provisions, then the successful resolution applicant shall submit his performance security deposit. The purpose is financial discipline and prevent withdrawal. So, as per the recent judgment, that security deposit made by the successful resolution applicant cannot be withdrawn until the complete implementation of the resolution plan. So it is in the form of bank guarantee, FD, lien, etc. Then refund on successful implementation, it will be refunded. Forfeiture on default. In Kundan Care Products case, NCLAT 2020, the forfeiture of the performance security deposit was held valid. And also in Supreme Court matter in 2001 judgment, Kalpray Dharamshi it says it observed the performance security deposit is essential safeguard. Like a landlord security deposit, refundable on good conduct, forfeited on breach. Then after the approval of the resolution plan by the COC, the Form H should be submitted by the resolution professional to the NCLT. The legal basis is Regulation 39 subsection 4 of the sub-regulation 4 of the SIRP regulations. The resolution professional shall submit the resolution plan as approved by the Committee of Creditors to the adjudicating authority with a compliance certificate in Form H. The purpose is Form H is a compliance certificate filed by the RP along with the COC approved resolution plan. When submitting to the NCLT under section 30 subsection 6 of IBC, it ensures that the resolution plan and the process comply with the provisions of the Insolvency and Bankruptcy Code, the SIRP regulations, requirements under section 29A, ineligibility test for resolution applicants, distribution priorities under section 30 subsection 2 subsection D. And Form H is a structured checklist which certifies details of corporate debtor, the name of the corporate debtor, the corporate index number, date of admission, commencement date, etc. Details of resolution professional, appointment, etc. Details of COC members, voting shares, and complaints confirmation. What all the complaints they made, it all it is reflected in the Form H to be submitted by the RP to the NCLT. So SIRP conducted as per IBC and regulations. The plan provides for SIRP cost, operation creditors, dissenting financial creditors, statutory dues, etc. Plan should be feasible, viable, and implementable. And also it certifies, the Form H certifies SIRP is conducted as per IBC and regulations, information memorandum prepared under regulation 36, evaluation matrix, bid evaluation matrix and RFRP issued under regulation 36B, resolution applicant screened under section 29A, COC approved the plan with the requisite majority, which is 66%. Then voting outcome of COC, including percentage of votes in favor, and other attachments like certified copy of the COC resolution approving the plan, summary of the resolution plan, affidavit of resolution plan, affidavit of the affidavit of the resolution professional on section 29A eligibility. These are all forming part of the Form H. Then the final compliance certificate should be signed by the resolution professional. It is like a covering certificate ensuring to NCLT that everything was done properly. Without Form H, NCLT will not approve the resolution plan. The resolution with regard to real estate, why it is different? let's ask ourselves, why are real estate SIRPs, that is corporate insolvency resolution process, different from other industries like steel or telecom? The answer lies in section 5, subsection 8, subsection F of IBC, which was inserted after the landmark Chitra Sharma versus Union of India 2018 Supreme Court case. It recognized home buyers as financial creditors. This means every individual home buyer is a financial creditor because there are thousands of them. No, the heir is appointed under section 21, subsection 6A, subsection B, read with regulation 16A of SIRP regulations. In other industries, there are usually 5 to 10 banks, financial institutions in the COC, but in real estate, you may have 10,000 plus home buyers. In JP Infratech Limited, over 20,000 home buyers were there. Resolution plan approval took years due to conflicting interest of lenders and home buyers. That is why real estate resolution plans have unique hurdles compared to other industries. Then major litigation hurdles during the implementation. Litigation is the biggest enemy of timely resolution. Let us examine these hurdles. How the hurdles resulting in the disputes being taken up before the Honorable NCLT regarding the section 29A eligibility disputes. Promoters or related parties try to come back through the connected entities. So, in ArcelorMittal versus Satish Kumar Gupta 2018 Supreme Court, strict interpretation of section 29A to prevent backdoor entry of defaulting promoters. Then another, in the form of refund versus possession disputes. Some home buyers demand refund. Is already stated that this creates conflicts within the same creditor class. Then government dues, tax and statutory claims. The next one is the RERA conflicts, Real Estate Regulation Development Act rights versus IBC process. Many home buyers are under the impression that after obtaining the orders, favorable orders from the RERA for compensation, they also once the process the corporate debtor is admitted in the corporate insolvency resolution process, the claims are invited and they have to submit their claim. Despite their having their favorable orders for RERA, they have to submit their claim, and the whatever that RERA compensation awarded, normally that also included in the, that is subsumed in the admitted claim of the home buyer. So they still believe that the IBC process will award them compensation separately. There is no such thing, but everything is subsumed in the admitted claim. Only admitted claims are being considered under the resolution plan. So apart from the RERA conflicts, the RERA conflicts, what happens in the Umang Realtech Private Limited, NCLAT 2020, IBC prevails, but resolution plan must protect interest of the home buyers. So in many orders also, NCLT has repeatedly stating that in the real estate insolvency, the interest of the home buyers is of paramount importance. So whatever the voting share may be less for the home buyers. Unlike JP or Amrapali matters, many cases home buyers voting share may be very less compared to the other secured creditors. But in spite of that, in the real estate insolvency, the interest of the home buyers are considered paramount and is very much appreciated by the NCLT, and also by way of direction to the RP with regard to the steps to be taken, and also with regard to the framing of the preparing the resolution plan for this by the resolution applicants. Litigation consumes precious SIRP time and creates uncertainty in approvals. So this is for many years we have been experiencing and telling that litigation, it's a very problematic thing for the resolution approval of the resolution plan and for the completion of the process. SIRP process, and so it consumes precious SIRP time and creates uncertainty in approvals. So they, since it is taking too long, no, they started disbelieving, and there's some kind of disbelief among the stakeholders, home buyers, including home buyers. Then one of the unique pain points in real estate SIRP is the role of the RWAs, Resident Welfare Association. RWA often push for reclassification claims. They want to know refund seeking buyers, possession seeking buyers. They want special preference, demand higher allocation, priority in allotment, litigation against the RP and ARs. These are all the these are unique pain points in the role of the because of the in the real estate corporate insolvency process is the role of the resident welfare association. Sorry, but the legal framework is very clear. Regulation 16A, sub-regulation 5, it says AR must represent the entire class of creditors, not the individual subgroups. Then section 21 subsection C, 6A subsection B, AR's duty is to vote as per majority decision of the home buyers. This creates friction. Home buyers who feel dissatisfied often pressure ARs, including through email campaigns and group protests. Yeah, we have experienced so many such occasions, and still, as a resolution professional or insolvency professional who also acts as authorized representative, we have to act in two different ways. One, as a representative of the home buyers, as to keep in mind the role as an insolvency professional, because the home buyers may not be completely aware of the law being followed by the entire being adhered to by the stakeholders as well as the RP and the AR. But still, since they are aggrieved, they want only their resolution of handing over of the flats and refund, etc. But it is the duty of the AR to make them understand and be patient and be responsive to their queries and in a timely manner, and it also ensure the peaceful implement in the approval of the resolution plan by the COC and also by the NCLT. The resolution plan, the copies are being not, it's very confidential. After obtaining, in one case, after obtaining the confidential undertaking, we give it to the home buyers. In fact, in one case, the NCLT itself directed the resolution plan shall be shared with the home buyers as well. So in spite of that, yeah, as per since we have to follow that, we obtain confidentiality undertaking and issue the resolution plans copies to the home buyers. But however, it is a duty of the AR or the insolvency professional to read the complete resolution plan so that he can make a representation in the COC about the valid points mentioned in the resolution plan, which are very favorable to the home. It should be favorable and ensure that interest of the home buyers are protected in the resolution plan before its approval or finalization of the resolution plan by the resolution applicant. So, it is a duty, and normally they get all the feedback from the home buyers. Then only accordingly they represent. Even some cases, many cases, since they are better placed in respect of the knowledge about the IBC and the things regulations, the resolution the insolvency professional acting as the AR should be aid the home buyers in understanding the correct their position, and their interests are protected through the AR in the COC meetings effectively. So with regard to the resolution plan, the experts' contribution is very much like registered valuers. They value land and incomplete projects. There are many projects, in one case, there are many projects left unattended by the erstwhile promoter, and it is during the no that after the appointment of the registered valuers, they have to value the land and ascertain the value of the incomplete projects. Then they have to the RP shall appoint the forensic auditors to investigate the diversion of funds and submit the Section 66 applications before the NCLT. Then they should also appoint the engineers and architects to assess their feasibility, cost to complete, construction defects, etc. So in many cases, the home buyers express no disbelief, or no, they have no confidence in the one of the resolution applicants, who is also the erstwhile director. Okay, he submitted the resolution plan. Since no, he has not done his part earlier, they started they don't want him to to be the successful resolution applicant like that. They express their own reservations about that, and it is the duty of the heir to communicate the same and in a proper manner, so that you have to doubly ensure the resolution applicant has the source of funds and to implement the project in a timely manner and in compliance with the regulations. Then the lawyers and company secretaries to draft resolution plans, their expertise is very much required. Check Companies Act compliance, etc. Section 66, Section 185 or 186 of the Companies Act. For example, in Amrapali case, engineers' reports were crucial in preparing cost to complete estimates that guided the resolution strategy. Experts convert a plan from being theoretical to practical. Then about the complaints and presentation, complaints is the backbone of resolution approvals. So if the resolution plan is to be approved, there should be very satisfactory compliance of the provisions of the law. Section 30 subsection 2, like SIP cost, as already stated, operation creditors, at least liquidation value, feasibility, legality of the resolution plan, compliance, etc. Then Form H, performance security. So RP's role during hearings, court hearings before the NCLT. RP is a process facilitator, is not an advocate of the plan. He must present COC minutes, voting results, valuation, Form H affidavit on Section 29A. Cannot argue on merits of the plan, resolution plan, only confirm acceptance. In case Shashidhar versus Indian Overseas Bank, Supreme Court 2019, NCLT cannot interfere with COC's commercial wisdom. In short, RP is a referee, ensuring rules are followed, not a player scoring goals. The critical aspects and early approval factors, some factors that contribute to early approval of plans in real estate cases, timely deposit of performance security by the successful resolution applicant as per the timeline mentioned in the law, as well as or the RFRP. Then pre-clearance with regulators like RERA and local bodies, so that once the plan is approved, it can be implemented smoothly. So then transparent communication with home buyers through the authorized representative, setting objections in COC itself rather than letting them reach NCLT, feasibility and viability of plans supported by expert reports. Example, in some smaller projects, plans were approved within 9 to 10 months, where objections were resolved inside COC itself. No, resolution is like a train journey. If all passengers like creditors, AR, regulators, RP board on time, the train reaches its destination faster. Before I conclude, let me recap. Resolution plans must meet Section 30 subsection 2 and are binding once approved under section 31. Real estate SIRPs are different due to home buyers as financial creditors. Litigation is the biggest hurdle. Experts must make plans workable. RP's role is neutral, ensuring compliance. Early approvals depend on preparations, clarity, and cooperation. In real estate, corporate insolvency resolution processes, resolution is not only about recovery of loans, it is about delivering homes and restoring trust for thousands of families. That is what makes these cases uniquely challenging and impactful. Thanks for the opportunity to deliver my presentation.
Beautiful presentation by sir. Thanks a lot. And we will seek some more help of you after this session, ending session, at the time of ending session. By
Yes, sir.
receive queries from our viewers, listeners in the program. So thanks a lot, sir. You have beautifully covered this entire session, guiding us on all aspects, pre-approval resolution plan, post-approval resolution plan, monitoring committee, and all required aspects, role of AR, monitoring committee, and all this our entire activities required in real estate resolution. But we seek your help. We are just
Yes, sir.
received one query. Can right now we discuss, because there is some time?
Yes, sir. I saw the question. Can
Yeah,
AR discuss on forensic audit report?
yes, sir. Yes,
Sir, actually, sir, what happened? The AR is no, as per the regulations, is not only to no forward the minutes and attend the COC meetings. Apart from that, they are, since they are representing home buyers, it is in their interest. The AR should get access of the forensic report, and also he can make some discuss the report with the COC, and if anything to be discussed or for the home buyers, he can always do it, sir. Nothing prevents them.
we have received one more query. Sure.
It's an it's an acknowledgement, sir. Thank you.
Okay, this is what. This is thanks for your kind presentation. Now, this is the time for our second speaker, who will discuss this, our regular resolution plan. So, Bhavita madam. Bhavita madam, kindly unmute yourself. We are not getting your voice.
Yeah, yes, sir, yes, sir. And
So, this session, our prominent, eminent member of this IPNet Central, Madam Babita Jain, will take and will guide us in general resolution plans. Babita Madam, qualified IP and Company Secretary. And directly we request her to start her session, please. Please, ma'am.
sure, sir. Not require much. I understand that as per my understanding, my topic is being shared as the implementation, and this is regarding the resolution plan, implementation of resolution plan under IBC, and impact of delays, impact and consequences of delays. Now it is my associate Sankran sir has deeply emphasized the procedure, how the resolution plan to be approved, and all the things to be considered. Yes, apprised, he has pointed out major provisions regarding the resolution plan. Now, ultimately, after the approval of the resolution plan, the stage comes in implementation of the resolution plan, and there has been so many problems are coming on implementation of resolution. Section 526 says the resolution plan is one proposed by the resolution applicant. This is basic facts, and resolution plan is to be completed and submitted within 180 days to 330 days. RP verifies, presented, and COC approval with 66% vote share after evaluation of viability, feasibility, and viability. Adjudicating authority approval under section 31, as I understand all of us are IPs, and these are the basic provisions we are being aware of it. And adjudicating authority, the issues the order that thereafter the order this became binding on creditors, guarantors, third parties, everybody, and the section and the this moratorium under section 14 come to an end. Once the plan approved, this plan overrides with the plan overrides any consistent law, extinguish the unaddressed claim. 32 provides clean select principle that the resolution applicant have got immunity from all the actions to be taken prior to the this is prior to the implementation, the initiation of CIRP of this plan. And key contents of resolution plan, however, Sankran sir has already been informed. Details of resolution plan, restructuring, whether there is the affidavit of eligibility, sources of fund, insolvency and operational creditors. Thereafter, there are restructuring measures, merger, amalgamation, debt equity swaps, asset sales to revive how the asset will be revived as a going concern. Payment waterfall mechanism as per section 53 is there. Priority of payment to insolvency first. Thereafter, minimum 100%. This is there is a distribution to the dissenting financial creditor not less than the liquidation value, and operational creditor not less than implementation schedule. That is already being provided in the resolution plan. Implementation schedule is also being provided in the resolution plan. Declaration compliance statement, this has also been there. And now the treatment of guarantees, employee claims, that is referred to each and every corporate and every resolution plan, this is being treatment of everything is different. Now, mandatory contents of resolution plan, that has already been discussed and apprised. The main plan is as regards the implementation. I'm talking about the implementation. Regulation 38, there has been some amendment is also there right now. The committee shall consider setting nowadays because of the failure of resolution plan, so many cases, this amendment was being done. Committee shall consider setting up of monitoring committee for monitoring and supervising the implementation of resolution plan. The monitoring committee may consist of the resolution plan or any other resolution plan or any other person, including the representative of representatives of committee or representative of resolution applicant and as its members. Where the resolution professional is supposed to be a part of monitoring committee, monthly fee payable to him shall not exceed the monthly fee received by him during the CIRP process. Third one is there, this is very important. The monitoring committee shall submit quarterly reports to the adjudicating authority regarding the status of implementation of resolution process. That's why the adjudicating authority, IBBI, all the authorities can take, can have an eye over the implementation of the resolution plan. Steps in implementation. Hand over to the CD within 30 days of approval of under regulation 38(4).
नहीं
RP
मैंने
handover
actually लिया था तो उस समय उस शायद कोई प्रॉब्लम हुई थी इसीलिए नहीं लिया था, नहीं तो मैडम यही बैठी थी ना।
और मैं तो फिर OTP लिया था।
हाँ तो वो उस समय तो फिर मैं यदि हो गया होता तो मैं आपको मैडम को दे ही देता।
please mute yourself, sir.
मेरे को
Ravi
भी
sir, please.
हो गया तो भी मैंने दे दिया, मेरे को दोनों के दिए थे, मैंने आपका और मैडम का दोनों का दिया था।
Hand over to the CD within 30 days of approval, regulation 38(4). The RP hand over the possession and assets to the SRA. SRA assumes the management control. Thereafter, the payment distribution as per the resolution plan, 90 to 180 days for initial transit sometimes, disperse the fund to the via escrow accounts, prioritize insolvency cost, then operational creditor, financial creditor, dissenting creditor will get at least the liquidation value. That we have to make sure. Restructuring execution as per plan terms, whether it is 24 months plan, 12 months plan, 15 days, whatever it is. Implement, there are some plans provide for mergers, debt restructuring, asset monetization. There are certain, we have to obtain certain approvals from the SEBI approval for listed entities. There are and there may be some other approvals may also be required. That is also taking time. Supervision and reporting. Ongoing RP monitor the compliances, files quarterly reports with IBBI, AA and SRA reports in case of any deviation. Completion certificate. When the SRA certifies RP and AA that and RP confirms and closes the process, and failure triggers potential liquidation. In case if there is failure, then there is a potential that is the very harm. There may be the liquidation also in case of. Now I just come to the challenges faced by us during the this implementation of the resolution plan. There are the severe challenges in implementation of the resolution plan. First of all, first is litigation delays. Appeals under appeal obligated under Article 226 or 227 of Constitution can stall the execution. However, we must the Honorable Apex Court. This has been pointed out. There is a scope of intervention by the High Court of the orders passed by the NCLT. In this case, in the case of Embassy Property Development Private Limited versus State of Karnataka and others, the Apex Court has outlined the scope of intervention by the High Court in case of the orders passed by the NCLTs. In these cases, these are the cases where the main just read the thing. Main points I am just discussing in this way. There is conflict in jurisdiction, and wrongful exercise of jurisdiction would be certainly taken into account by High Court when Article 226 of Constitution of India is sought to be invoked. This is important invocation, ultimate result in bypassing the authority of NCLT. The order of NCLT as per IBC that is being challenged at NCLT. However, it is going to now High Court. In that case, embassy case matter, I'm just saying there is the government mining lease control granted by the corporate debtor to government of Karnataka. That was as per the Mineral Concessions Act. There is the three other person. This is the government of Karnataka refused the benefit of deemed extension of lease that was in public law domain in lieu of the same correctness of the decision. Supreme Court, that is Apex Court, pointed out the status of Superior Court having the power of judicial review and administrator could not be elevated to the status of Superior Court having power of judicial review. Supreme Court held the only provision that could help outline the scope of jurisdiction of NCLT in respect of any decision taken by the local act, or here in this case MMDR Act under Section 65. Ultimately, the Apex Court held any decision taken by government statutory authority in relation to matter which is in the hem of public realm cannot be done by stretch of imagination, can be brought within the fold of the Section 238 of IBC or arising out of the insolvency resolution. That cannot be done like this. Now the frivolous bits and disputes. This is also biggest problem arising out, that there are the frivolous disputes and frivolous bits that may be the hurdles being created by the promoters of the company. Some people have as we all are ITs, we understand that some people have the nature to put a bit, whether they will admit it or not, whether they have any interest or not. Bid to dalne, that's all. They have to put the bid. That also hurdles the time. That is also hurdles this our and dissenting creditors also. Dissenting creditors challenge the distributions. This is also one of the problem. Section, however, that to be decided by the judicial authority within a time provided. Time provided, therefore, their time is the essence of the resolution plan. Regulatory hurdles. Sorry. Interplay between the SEBI takeover court, minimum public shareholding requires exemption, time exemption, that is also the funding and execution rate, delay in asset monetization for fund infusion. This is also causes whenever there is the resolution plan says the sources of the fund. When it says this much amount will come from the asset monetization, then the problem arises if there is delay in monetization of asset by whatever the reason caused there to, that is also added to the delay in resolution plan. So now timely implementation of the resolution plan is major objective of the IBC. Sorry. Timely implementation. One of the matter we have been seen in Jet Airways also. There is the Supreme Court, clearly they have given the time. We have already seen that the adjudicating authority and appellate authority, they are giving time from time to time that the resolution plan, their time giving for extending the timelines for adherence of that. Even then, there is the no option was left to direct the liquidation as we have seen in Jet Airways. NCLAT has given time. Even then, they have not being implemented. That 5 years has been lapsed in Jet Airways. 5-year delay in implementation of the resolution plan that was being initially approved in 2019. There was no option left for the corporate debtor to go into liquidation. Supreme Court further emphasized the responsibility to implement the resolution plan in a collaborative one, not solely resting upon the SRA. Lenders, creditors, they are equally obligated to facilitate the process and offering constructive and ongoing cooperation. They must avoid hindering implementation and unnecessary demands to the resolution professional beyond the resolution plan. That is also delaying staff and the corporate debtor ultimately go to liquidation. Nothing will be come in our hand. This is the basic. These are the basic facts that has been coming to. Speed is the essence of working of the IBC. One of the two reasons when we for the working of the IBC code for two reasons. We have two reasons. First, the calm period, that is section 14. We have given full clarity of ownership and control. Significant decision cannot be made without leadership. The firm land to a drop and fail. The longer the delay, the more is the chance to go into the liquidation and will be the only answer. Liquidation value also tend to go down and the time as many assets suffer from a high economic rate of depreciation. This is also one of the major reasons for failure of the resolution plan. Hurdles and being delay in implementation cause the adverse effect on economy of the company. First, however, we have seen the BLRC when it comes, BLRC report, it make it very clear, setting out the objectives of IBC for the country, speedy resolution and decision making in insolvency situation was stated as one of the foremost objectives. That was our time, speedy resolution and decision making. However, we all are RPs and we are aware of what the system is COC. There is no imposition of law on COC. They take much time for approval of the resolution plan, and there is that will create a much problem, and that is the RP unable to adhere to the timeline, they are again and again to the adjudicating authority for extension of. There is the insolvency situation. The business and relationship and underlying business can deteriorate very quickly. Intrinsic value of the business is very crucial. Therefore, to salvage the value of the business, it's crucial bring effect in a formal framework which can cause negative consequences of a of this situation. Like it is with that the IBC provides trigger of CIRP to be mere default in repayment of debt. As earlier, this is inability to pay debt. Admission brings out moratorium on all legal proceedings and enforceability of the security interest. Even during the moratorium of ongoing CIRP, economic realities can change very quickly. To begin with, on account of moratorium, financial creditors have to forsake their interest. 180 days, 330 days, 5 years, 3 years, whatever the time is going on. Their financial creditors' stake is also freed up to a certain extent. One could justifiably give up it for sake of efficient reason in making, leading to the early resolution. The longer it takes to conclude CIP, the greater distress on account of delay in financial capital. Apart from the above apart, the cost of insolvency is significant, and the entire cost of CIRP process, along with legal and professional costs for running CIRP as well as operational costs, are quite high. In circumstances where the corporate is cash strapped, there is provision for raising the interim finance. In practical reality, we are fully aware of it is very difficult to raise the interim finance and to run the business of the corporate debtor during the CIRP. The financial criteria, anybody who want to invest in the asset, they want their security. Already they have lost us too much money and they don't want to infuse further funds to save the corporate debtor during CIRP. This is one of the more major reasons where we are suffering a lot. Preventing delays in CIF and preventing delays facilitate the CIRP conclusion and in a timely manner and practical manner. The process under CIRP, the processes under the code have witnessed two significant factors. There are the two significant ones: the resolution professional and the committee of creditor running the process to allow, they should not be allowed to make the last minute changes in the resolution plan that involve the cost as well as that involve the cost. That is last, even this is the maximization of value of the asset. They have the name of maximization. Last minute, advance the resolution plan. Too much litigation delays contributed significantly to overall delay in conclusion of sale. Lastly, the delays in process cost significantly to the participating bidder as well as the participating bidder, as well as by participating the bidder have to keep block their own or borrowed fund till the successful completion of the process. This blocks the significant capital in the economy that is being stuck in the form of bank guarantee or in the form of cash or something like that. Because of the delay till the conclusion of CIRP, the decision there to being a subject matter of long drawn litigation battles. This is the sense of this is likely the complete sense of economic wastage also. And that will also cause one of the cause for failure of the resolution plan decision. However, everybody in the BLRCA, whatever it is, every time we are insisting for time is the essence of the implementation. Large haircuts in the time of expensive proceedings, and CI ever increasing time involved in litigation processes, approval of a resolution plan, approval of this other processes, that is also very important. This is the time, we are every time IBCs, IBC and NCLTs and all the judicial firms, they have been the aim to time is the essence of every process. that is being such as delays dissuade the participation from potential resolution applicant. They adversely impact their commercial assessments. For this reason, an applicant whose plan is pending for approval of the NCLT may end up seeking modification or even withdrawing a claim of change in commercial. This is the commercial base upon the resolution plan. No, there is the resolution plan. There is no way out for the resolution plan. This is the real deal to implement the resolution plan. In the matter of ABEX, I have seen ABEX Singapore versus Committee of Creditors. Apex Court submitted the resolution plan. Cannot be subsequently. This resolution plan cannot be subsequently withdrawn at once the approval, even after the approval of the COC. This resolution plan cannot be withdrawn. This is the non-returning saga of the of resolution plan. In the matter, this MTech Auto, the Supreme Court thwarted a successful resolution applicant who relied upon open-ended clause in the plan from seeking direction to compete to compete the COC for negotiating or modification already approved in the plan. At once the resolution plan should be approved. That should be there. The modifications should not be very much possible. The applicants has been disallowed from modification in the approved resolution plan. The court observed that leaving any scope of negotiation after its approved plan would be contrary to the IBC. In subsequent proceedings, court gave direction and expeditious implementation of a resolution plan, and as well as timely completion of the insolvency process. Interestingly, the court relied upon Section 12 of the code, noting that how delays the plan implementation, the very subject of the statutory time limit is stipulated in completion of the CIRP process. Initially, we are talking about the ABEC. The court refused the applicant to withdraw an approved resolution plan. It referred to the Regulation 38 of CIRP regulation, ruled that the plan whose implementation could be withdrawn at any any successful applicant behest is inherently unviable. Accordingly, the question of plans binding nature cannot be undermine the discretion of very potential. Negotiation of the COC will end when it approves the plan, not even subject to the final approval of the NCLT. These enjoy limited power of review. The NCLT enjoy the limited power of review. Such review cannot trespass upon the business decision taken by the COC in exercise of all these persons. Another major change challenge impossibility or lack of implementation of the resolution plan. There may become like force majeure clause comes, frivolous nature of which comes. As noted, the Supreme Court has been reluctant in permitting the withdrawal of modification of resolution plan as approved by the NCLT. However, in one of the matters, Satyanarayan Malu versus SPM paper mill, NCLT permitted the withdrawal of resolution plan. It gave effect that OTS has been reached between the parties. NCLT stated that the plan approved by COC had become redundant and the issue required no further adjudication. The threat of implementation of resolution plan in a scenario when the corporate debtor is uninterested, the resolution applicants seek one-time settlement by making lesser payment to the creditor and protect it from unwarranted takeover or restructuring. These are the whatever is the at present the need of the implement the resolution plan without any further intervention or supervision, especially in jurisdictions following debtor in possession model. No such supervision is mandated in countries where the procedure conclude a plan becoming effective. Sir, in take successful resolution plan, the open-ended clause, I have discussed that. Now, the Supreme Court judicial development as of now in Kredan infrastructure, I think everybody has read it. Even then, we are reiterated it. A resolution applicant must be fair in dealing. Resolution applicant in this case submitted a resolution plan which was approved by NCLT and which was due to SRA's failure to implement the plan. An application was filed under Section 33 for seeking liquidation. Thereafter, SRA preferred an appeal before NCLAT, granted an opportunity to submit the revised timeline for implementation of the fund. The NCLAT allowed revised timeline as per the terms agreed by the members of the erstwhile COC and SRA and the liquidator. However, since thereafter also this appellant did not adhere to the aforesaid term, NCLAT upheld the liquidation order, and the company that was being challenged in Apex Court directed the forfeiture, Supreme Court, it directed forfeiture of 20 crores, which was earlier deposited by SRA as a part of implementation and of the resolution plan. In recent, Kalyani Transco and Bhushan Steel, that was the very, the sigh of relief we have taken just yesterday. That plan is being again affirmed by the this Apex Court. The court directed return of in that matter. Previously, the Apex Court has directed the return of payment made by the SRA to financial creditor, operational creditors towards contribution within 2 months from the date of judgment. Apex Court in this case ordered the liquidation of Bhushan Steel and Bhushan Power and Steel Limited and rejecting the resolution plan of JSW Steel. The judgment came over 3 years after when JSW has started execution of the obligation under the resolution plan. The Apex Court held that the resolution process did not duly discharge its duties under the code and COC failed to exercise its commercial wisdom while approving the resolution. However, 2 days back that is being review petition was being filed, and thus 2 days back this resolution plan is being affirmed by the in review petition. I will discuss this in later. This case, JSW matter. Just I brief again this whatever what work they have done in JS in this matter. Punjab National Bank has initiated CIRP BPCL under Section 7. Several resolution plan was submitted. JSW plan was approved. That plan was approved to certain conditions. Several appeals was filed before NCLAT against the judgment of NCLT. Why JSW suspended directors and operational content. NCLAT upheld the approval of resolution plan with some modification as agreed. We must understand this in 3 phases between the JSW. RA has infused in 2021 to 2022 equity of 100 CRs and make the payment of 19,350 to the financial creditors of the BPCL in 2022 and approximately 350 CRs to the operational creditor in 2022. However, when the Supreme Court invalidated for various reasons, including procedural informalities, non-compliances, and mandatory provisions of the Supreme Court. Now, this decision has been come to the fact. The Supreme Court has affirmed the resolution plan of JSW in this matter. The issues raised in between there is issues involved in that case. What is the locus standi of the promoters, erstwhile promoters? The term person aggrieved under Section 62 is not defined. However, the objective of IPC to purposes interpretation to ensure expeditious resolution and balancing the shareholders' interest. IBC's objective to prevent undue delay and time-bound resolution plan. Accordingly, there is no locus standi where the conduct of promoter is very relevant. They have no locus standi, but the conduct of promoters is relevant in that case. There is the conduct of the promoters. In that case, NCLT found that the promoters attempted to delay the proceedings, filed multiple applications, and were imposed the cost for this frivolous conduct. Existence of COC after approval of the resolution. When the initially IBC came, I have my personal experience is that because I am dealing with the NCLT Allahabad appearing, there was the COC became ex officio after at once the after 330 after 180 days or 270 days. Now these days are 330. But in this judgment, there is the that is the appellant argued that COC became ex officio after plan approval. But in that case, COC interest outline and existence of COC even during the implementation of the resolution plan. This is not very, I have not done much exercise with that because judgment come day before yesterday. And this separate session will be taken up by the Ashish sir with full full description of the plan. I think he will certainly हमें अच्छे से समझाएंगे कि इसमें क्या गलत हुआ है, क्या मतलब हम कैसे इसको करेंगे. Existence grounds of appeal. There is the appeal arises from the findings of NCLT and NCLAT. Supreme Court, not only the question of law, NCLT appeal on five grounds. There is the Supreme Court under Section 62 allows the appeals to the Supreme Court only on the question of law. Present appeal do not fit within these grounds. No question of law arises in that particular case. Nevertheless, even then, the court addresses the contentions on merit. Legality of cause clause permitting COC to extend the implementation. Appellant challenge that how they have extension with the court find clause only allows extension by 66% of COC majority, no modification or withdrawal. No negotiation, no or modification clause is valid and not indeterminate. Delay in implementation of the resolution plan. Delay was due to multiple legal impediments, CBI ED proceeding, asset attachment, interim stays, and lack of clarity on asset handover. In that cases, when there is CD and EBI, CBI and ED proceedings are going on, then there is the asset attachment. Removal of the release of the asset from CBI ED is the biggest task. Both COC, SRA and JSW has made consistent efforts for implementation. Delay was not attributable to them. There was this resolution, the Apex Court has also distinguished this Murari Lal Jalan judgment, that is Jet Airways judgment. There was delays because of the delays was attributed because of the inaction on the part of SRA action. Here the delay was not attributable to them. Contravention of law, priority of the payment to OC, that we have already seen that that when the amendment didn't come, resolution plan was compliant with law as it stood at that time. Amendment to Regulation 30A comes after plan approval do not apply retrospectively. Upfront infusion of funds by SRA. Appellant urged that SRA JSW failed to infuse committed equity. SRA JSW infused balance ECDs which qualify as equity per Supreme Court precedents. Supreme Court COC confirmed compliance. Commercial wisdom of COC is justified. Now there are the contingent claims are also there, that also all been taken. Pre-CIRP dues of, that is no evidence of what there is any pre-CIRP dues cannot be paid. There is also one of the point raised by them. This Supreme Court in crux of the matter, whatever I understand, the Supreme Court held that the appeals by outside promoter or operational creditors lacks merit, and resolution plan and implementation were in conformity of the IBC and the applicable regulations. COC continued its existence, and the validity of extension clauses, treatment of payment, equity infusion, classification of claims were all upheld while the matter of commercial wisdom and settled down. Distribution of EBITDA was not permissible in the absence of specific provision of RFRP or resolution plan. NCLT judgment was affirmed. All appeals were being disposed of. There is any. Thank you, sir. And now we can have a discussion on any topic thereon. Thank you so much.
Any query from members, anything they specifically require from our learned speakers? Queries will be welcome. There are certain small things which
Yes,
I want to mention,
yes, sir.
like I am appearing in Delhi bench where that bench is very vigil. So they ask that in this resolution plan, why you have approved, why COC is approved for this small value, why they have not tried to increase the value. So for that, I have taken that current market price, there are new projects coming there, and there are various hurdles. So after a long argument, I was able to say compel them to agree on my points, and they are agree for the resolution plan. They have taken some time. So this kind for
Yes,
to mitigate all these things, we need some certain local nearby projects value, pricing of that projects. In another project, our honorable NCLT was expecting ki usually there is a practice that all extension, we won't take extension after filing of the resolution plan. But as ordered by them in one case, that we should file extension application till the approval of the plan. In between, we have to file the continuous application for the extension of the plan. This is
right.
Delhi bench. So these are the some
Sir, what
aspects.
happened, sir? In one of my cases, this was happened. My resolution plan, IA was reserved, but they have reopened it because of that the plan value was just for 10% of the admitted debt, less than 10%. I understand. Then he has been asked me to submit the details of. I have submitted them the few judgments in connection, even below of the COC can approve the resolution plan even below of the liquidation value.
Yeah.
I
Right.
submitted the valuation reports and फिर भी उन्होंने किया approve plan, but बड़ा
Yeah, they
मन
are
खराब
doing, but we have to take due diligence and
we
due
can't
care so that our plan should be approved in a single short.
single. Yes, sir. Yes.
So now, thank you, ma'am, for your this
Sir,
great guidance.
sir, may I add this, sir? Sir, one of the key amendments in the new amendment bill, sir, about the
Yeah.
resolution plan, it mentions two-stage approval for resolution plan. On an application filed by the RP, the adjudicating authority can initially approve the implementation plan for handing over and managing the business of the corporate debtor, and then the adjudicating authority separately approves distribution to the stakeholders within a 30-day window. The amendment also proposes to clarify that once adjudicating authority approves the resolution plan, the company gets a fresh start, that is clean state, meaning all old claims against the company are extinguished except those specifically allowed to continue. So this speeds up process in cases where distribution mechanism acts as a roadblock for implementation of the plan, sir.
Sir,
Yeah.
which section is that, sir? May I
No,
read
no,
out?
it's
It
proposed
is
amendment. Let
It's
it be.
section
proposed
31,
and,
sir. Section
section
31, madam. Clause
amended.
90, yeah, 31.
Okay, I'll read out it. But still, that is not even not.
Yeah, let it be approved because
Yeah, yes.
it will
Not-
expedite
not
a lot
yet.
of things. Yeah.
Yes, sir.
So thanks a lot for our both speakers. That memento we are giving, just a moment, to our learned speakers, that I am giving this. Extremely sorry that our key persons are not here. So I will try to share the screen. So I am sharing the memento for our first speaker, Babita madam,
Yes, sir.
I request you that my screen is not, that memento is not available to share. Can you please help me,
Yes, sir. एक minute, sir. I just help you. I just share this.
please?
This the memento to IP Shankaran, sir.
Thank you. Thank you.
Thank you, sir.
Thank you, Shankaran sir.
Thanks for the opportunity, sir. It's my privilege to attend this webinar. Yeah. So, speaking.
Thanks for your guiding us, and one memento for Madam Babita Jain. Again, that I will give you, but I need that screen sharing from you only. That is required.
Yes, sir.
Thank you, ma'am. Thanks a lot. Our sir is stuck up with the traffic and there are no more queries. So this is for you, ma'am, for
Thank you,
sparing
sir.
and
Thank
guiding
you.
us, sparing valuable time, guiding us. Thanks a lot. Thanks a lot for to all these our
Sir, we have
viewers
one
and
more
participants.
memento. I have one more memento for Sanjeev Chaudhary, sir, for his job as sir. I'm just sharing that also as a moderator of this today's event.
So thanks a lot, ma'am. And
Thank you,
thanks
sir.
to all
Thank you.
the participants for sparing their valuable time on this festive moment. Thanks a lot, sir. We are
Thank you.
concluding
Thank you,
with
sir.
this.